my name is Sandra Olson, and I'd like to talk to you today about DNA testing, human rights, justice, or the lack thereof, and the Evidence Act, the Attorney General of Canada, and our judicial system as it applies to all British law countries. DNA came onto the scene with a flashbang approach where the word of God in it cannot be disputed. It's irrefutable science. No one has bothered to mention that there are no scientific studies to verify the accuracy rates so diligently claimed by these people. I have a statement from a genetics professor in the US, Jason Gilder, and he admits there are no studies to verify the accuracy rate. All they have are one or two simulated studies. Simulated studies are not using real samples. It's a basic mathematical sort of exercise. So, my daughter is a lovely woman, and her father is Asian. His name is Rick Wong. And the DNA test was done at Vancouver General Hospital in 1994. And it was done on 3 loci, which is spots on the DNA. And based on that, he was excluded as her parent. She is definitely his child. I have approached the court repeatedly. You cannot accidentally look Asian. You can clearly see that I am not. So, I have been in court and I have asked over and over for the privilege, something that is actually guaranteed under our judicial system is the right to examine the evidence and question the witnesses. And I have never had that privilege. And in fact, within the last 3 weeks from when I speak to you now, I went to court again, requesting simply the privilege of examining the evidence and questioning the witnesses before we go to trial. I was denied. The justice system apparently feels that they can assess the merits of a case without the merits having been established. This is a gong show, a judicial gong show, and they know it. What they're trying to do is make sure that nobody hears or is aware of what has been going on because they know they're fraudulent. The claims of accuracy in DNA testing is a complete fraud. The Auditor General of Canada has done 2 audits on the forensic DNA industry. Guess who they audited? The RCMP. So the RCMP are creating their own evidence. They answer to no one, and they're virtually unaccountable. So the DNA industry have no verifiable standards, no regulatory body, and no scientific studies to verify the accuracy rate they're claiming. And so my question to the judicial system was, what is this doing in a court of law? It doesn't meet our evidence standards. It doesn't come close to what we, as a democratic society, have the right to expect of our judicial system, because you're supposed to have a fair, equitable, and impartial trial. How can it be fair if you do not have access to the information needed to go to trial? How can it be equitable if you do not have the evidence necessary? The courts don't care. They're busy trying to get rid of this as fast as they can. They've already done it to a woman I'm aware of in Australia who is up against it the same way. And there's another woman that I'm aware of down in the States, although God knows I'm sure there's many more. And they're going to continue. We're women without resources. We represent ourselves. We have no lawyers. Lawyers run from this sort of issue because it tackles criticisms of the judicial system. It means that we are now saying to the judicial system, you failed, you were negligent, you abandoned your responsibility to ensure that evidence that is admitted into the court actually has merit. So if the evidence has no merit, the best way to get rid of the complaint is to do the most unthinkable, which is to strip my charter rights to access to justice. Yes, our charter gives me the right to access our judicial system if I should wish to. And now they're getting set to strip my judicial rights and demand that I no longer be able to take this issue to court under any circumstance ever. How's that? And we're living in Canada. Oh, the land of the free. I think not. So, I invite the public to go along with this little horse and pony show. We're going to go to court February 24th and 5th on the issue of the merits of the case. I'm sure I will be dealt with as swiftly and as efficiently as my friend in Australia was, and be barred from access to the court permanently. Of course, my daughter, when she turns 18, will have the right to take the issue to court. They'll do the same to her. They've stripped her of everything she has been entitled to and slandered me. At one point when I was standing in court simply asking for the privilege to speak and present what little evidence I have, the opposing counsel, a Karen Zimmer, stood up and actually said in front of the judge, I bet she doesn't even know who the father is. I don't think you get closer to slander than that. And the judge said nothing. So apparently she went along with it. That was Justice Russell. The other lawyer who was representing Mr. Rick Wong, Sarah's father, is Paul Reimer. He's considered to be a friend of the court, which is loosely associated with the Attorney General's office, who, by the way, have an obligation to instruct the judicial system on proper procedures and information regarding evidence, and has failed so miserably in that. He snuck into court in Vancouver, which is about an hour and a half's drive from me. I am in Chilliwack, while simultaneously guaranteeing me that I would be able to cross-examine his witness, Mr. Wong, in Chilliwack on the very day that he snuck into court and had my case dismissed with costs against me. I have been declared a vexatious litigant simply because I'm saying things that are very politically unpopular. Recently I've heard the phrase, judges forget that they're appointed and refer to themselves as the anointed. These were certainly people exercising that thought process. I do not go along with the idea that justice is only for those who are saying what is politically correct. I think that the idea of justice is supposed to be truth. And if you can't accept the idea of an examination of the evidence, an examination of the witnesses, before you talk about the merits of the case, then you're definitely trying to railroad this through the system as quick as you can, because nobody wants any of this to be noticeable. My lawsuit will no doubt grind to a stunning halt after these people get through with me, so I will take it to the public, which is you. I invite you to go onto our website, We've developed a primary one. We're still adding to it. It's DNA errors at freehomepage.com. And if you type in DNA, human rights and justice, you'll probably pull up Pat Farnell's page, my friend from Australia. She has several of them out there. We're continually trying to reach past the lock stand approach to the release of this information. There is a study out of Arizona done by a Catherine Troyer. She's probably the only woman who's ever done an actual study of real people with DNA testing. She did a study on the 65,000 inmates in her database and found that something close to 165 of them had matches at either 9, 10, or 12 loci, spots on the DNA. And so matches. I mean, if you were going for a criminal conviction, one of these, if you relied on it, would convict you. And these people were, one of them was black and one was white. And they had a complete 10 loci match. They were not siblings. There is nothing to suggest that Arizona has a very large database of crime families. These are studies. She did an independent study. The FBI came in and obtained a gag order to shut her down. Unfortunately, and thankfully for us, it was after she had already released this information. And then, of course, there's also the small story of the San Francisco's crime lab. DNA evidence could be tainted by concealed mistakes. I invite you to pull that one up. It appears that they found mistakes and then tried to hide them, and then they are now speculating how many more have been hidden. Well, we are the hidden. You're talking to the hidden, and there are so many more of us. It's just that as women with children, we don't have resources to take on government agencies, and it is their goal to make sure that you never find out about us. They are trying to bar us from the court systems successfully. They are trying to make sure that we are never printed. I attended one medical conference back in, I think it was 96, where I booked an opportunity to speak. The public could just do that. They didn't pay much attention to me because I hadn't been speaking much by then. I got up and I spoke, and afterwards I was mobbed by people asking me for the paperwork to prove what I was saying, which I provided, after which I tried to find many other public speaking opportunities, and every time I gave my name, they would never permit me to speak again. So, fraud is the willful withholding of evidence. Our judicial systems are now fraudulently withholding evidence that makes them look bad and is stealing from children. And I can't say that they're going to concern themselves with this. And so I'm asking the public to concern themselves with this, because if this is happening to me and to my child and to my friend in Australia and my friend in the US, and there was also the young woman I contacted in Africa. This is happening over and over and over. It's just that our communication systems are getting better, and now we have an opportunity to sit down and actually talk about what's happening and how. Our judicial systems don't want us to have that opportunity. They're